and welcome to Sera and Sauti. We are joined by Dr. Mugambi Laibuta, a legal scholar who has been at the forefront of Kenya's legal and policy debates on privacy, data protection, and constitutional rights for over a decade. He is the chairman of Data Privacy and Governance Society of Kenya, and his work has shaped national conversation on how to defend civil liberties and personal freedoms in the face of expanding state power in a digital era. Karibu Daktari.
Thank you. Thank you, Sumaya, for the invite.
I think we'll just go right into it. When Kenya adopted the 2010 constitution, we didn't have smartphones or M-Pesa or social media. Take us back to that moment. What were the framers of the constitution thinking about when they wrote about privacy and dignity, and how that ties into data protection as the foundation? Because in 2015, in the heyday of blogging, you found yourself representing some bloggers the state was coming after. And this is when the issue of digital rights started becoming central to the work you're doing and its connection to freedom of expression and freedom of press.
The right to privacy has been in Kenyan's constitutional text since independence. So the Independence Constitution had a provision against unconstitutional search and seizures, whereby the right to privacy of the individual and someone's house or home or property was guaranteed under the Constitution. So this provision was always in the Constitution, even when the Independence Constitution was amended so many times, that provision still remained. So when people went to court challenging illegal searches of their houses by, for example, the police, the court mostly would rule in their favor, saying that the police ought to have carried out those searches in line with procedures set out, for example, in the police standing orders and in the criminal procedure code. Now, when Kenya was clamoring for a new constitution. So there was clamor for constitutional change, since the 70s, then towards 80s, 90s, etc. One of the provisions that was always in the proposed draft constitution was a provision on the right to privacy. Then around 1998, when people were discussing the millennial bug, so at that point, people are saying at the turn of the year 2000, that there will be some sort of catastrophic or other kind of event that was facilitated by technology. So around 1998, Kenya's parliament started debating, and this was championed by Dr. Shemo Chuodho, who presented in parliament and said, with all this technology that is coming in, especially that time, I think it was like Yahoo that was mostly used, and I can't remember the other popular platforms then, that there was need for Kenya to come up with a Data Protection Act. So that was debated between 1998 and 2000. When you look at the Kenyan Parliamentary Hansard, you'll see those discussions about the need to have a Data Protection Act. But for some reason, that Data Protection Act, when the Attorney General was asked to draft the bill, for some reason it wasn't drafted. Then come the Kenya constitutional review processes. So when the late President Mwai Kibaki stepped into power in 2002, one of the critical agendas was to revive the constitutional review process. And that time, so when you look at the what we call the guide draft or the constitutional CKRC, Commission on Review of the Constitution, the draft had a provision on the right to privacy. So did the Bomas draft, had a provision on the right to privacy, right to dignity. The draft constitution that was rejected in a referendum in 2005 also had a provision on the right to privacy. So in all these discussions, there was always that provision on the right to privacy. So when you look at the Hansards of either Bomas or CKRC, this was not a provision that was heavily debated, but Now, of course, the draft constitution was rejected. Then in 2009, 2010, Kenya, again, what gave us the current constitution, there was a lot of discussion about the need to have a new constitution. So all the draft constitution by the committee of experts had a provision on the right to privacy, and the right to dignity, and the right to freedom of expression. But of course, there was some push by Parliament, and it was rumored that the national security agencies did not like this strong provision on the right to privacy. So they wanted it watered down. But that proposal to water it down never sailed through. So then now, that's how now, when the Constitution was promulgated in August 2010, then now we have the provision on the right to privacy as it is, a provision on the right to dignity, a provision on the right to freedom of expression, a provision on the right to access information. So with that history, just to show you that Kenya, I mean, in terms of principle, has always had this provision on the right to privacy. So then the question is, how then did we come up, did data protection come up? So when you look at Article 31 C and D, it also talks about information about individuals and their family are necessarily revealed. So even before the Constitution 2010 was promulgated, I think around 2009, civil society was pushing for a data protection bill. This bill did not see the light of day, but it was there in the public domain that there's this proposal. Then when the Commission on the Implementation of the Constitution also, I think, had a discussion on this data protection bill, but also for some reason it didn't come to pass. Then now, I think around now 2018, 2019, the government wanted to have Huduma number. And because government wanted to implement Huduma number, which is a digital ID, civil society challenged that, one of it being the Nubian Human Rights Commission. So the argument was that you can't have a digital ID in Kenya without having very comprehensive data protection laws. So this petition was taken to the High Court as a constitutional petition challenging Huduma number, the digital ID. And at that time, there was a data protection bill that was being proposed at the Senate by Senator Gideon Moi. He was the one leading that process at the Senate. But because of this Huduma number debate and the rejection and the petition at the High Court, the leader of majority then put into Parliament a bill that had been drafted by the Ministry of Information, Communication and Technology. So there were two bills. There was the Senate bill, there was the National Assembly bill. The Senate was prevailed upon to withdraw their bill. So it's the bill that had been drafted by the Ministry of ICT and then presented to Parliament by the Leader of Majority that now was debated and enacted. And that's how in November 2019, Kenya got a Data Protection Act.
For those of us who aren't lawyers, can you walk us through what the law was trying to achieve with the Data Protection Act and also with the creation of the Office of Data Protection Commissioner? What is the mandate of this office and what are the key areas within the legal framework that we as Kenyans should be aware of as crucial?
So why the Data Protection Act? So I think, as you mentioned earlier, technology has been evolving. And when you look at the debate in Parliament, in the Kenyan Parliament between 1998 and 2000, the debate was always that there are corporate entities, the individuals who are taking Kenyans' data, Kenyans' information through digital platforms, and therefore there's a need to protect Kenyans' personal data. Another argument was that even with the promulgation of the Constitution, Article 31 of the Constitution was sufficient because Article 31 provides for the right to privacy. But then the argument, there was also argument that it was not sufficient. We needed to break down this right to privacy, because Article 31 talks about every one of us has a right not to have our cells, our home, or our property searched, our possession seized, or information relating to our family or private affairs unnecessarily required or revealed, or the privacy of our communications infringed or violated. So there's need to unpack Article 31 of the Constitution through an act of parliament. And across the world, there were countries that had packed what the right to privacy really meant, especially in terms of personal data. So when you look at Europe, for example, they had privacy directives. Then they came and passed the General Data Protection Regulations called the GDPR. So across the world, there was a trend that in as much as there is a right to privacy in the Constitution, there was need to have very specific guidelines on how to deal with personal data. And it is for that reason a data protection bill was proposed in the Kenyan Parliament from around 1998 to around 2000. So that reason that civil society between 2009 and 2019 also pushing for a data protection act to be enacted in Kenya. So it was to broaden this, what we call the right to privacy. Because our personal data, it had been realized that our personal data, how it is collected, how it is stored, how it is shared, could have both positive and negative impacts on an individual. And so there's need for a law that will deal with the potential harms and potential risks of somebody having our personal data, either for a commercial purpose or a public purpose, whether it's government, private sector, businesses, not-for-profit, etc. That's why when you look at the Data Protection Act, it has principles for handling personal data. It provides for rights of data subjects, and data subject is basically you and I, humans from whom personal data is extracted from. So that is the principle around this, is to ensure that anybody handling my personal data, anybody handling your personal data abides by some certain minimal standards, minimal principles, and that in the event that I am aggrieved how my personal data is being handled, then I will have recourse to an institution that is set up by law. And in Kenya, that institution is the Office of the Data Protection Commissioner. But also remember, even before the Office of the Data Protection Commissioner was operationalized, before the Constitution, the Constitution 2010, even after the Constitution 2010, people will still go to court and say their right to privacy had been violated. So, but now, the law made it specific and provided for an institution that would not have the same level of very strict procedures like the courts, and thus we have the Office of the Data Protection Commissioner, which ensures that anybody or any institution, whether in public or private sector or not-for-profit sector, when they are handling individuals' personal data, and here personal data is any information that can identify a human being, that they are complying with the principles that are outlined in the Data Protection Act. And if you don't comply with the provisions, the Data Commissioner will take action. You and I also have the powers or the rights to complain to the Data Commissioner where somebody mishandles our personal data. And the Data Commissioner is in a position, for example, to issue a fine against that person who has mishandled data, and also award compensation from that individual who has been aggrieved by how their personal data has been handled.
It's interesting that you brought up the handling of personal data and the need for both private and public sector to comply. But we've seen a few years ago, some digital lenders were penalized, and this led to CBK declining their license because they hadn't complied with the data protection laws. But some Kenyans argue that the data commissioner falls short when it comes to challenging government misuse of our data, especially during this period. The past 2 years, it's been far more, how will I say, like intrusive, rather the state.
Yeah, okay. So I think since maybe there could be new information, but the Data Commissioner has taken action against two public institutions. I think it's the county government of Migori and NSSF or NHIF. I always sometimes confuse the two. But so there are two institutions that the Data Commissioner has taken action against. Now, yes, so it's true that when you look at the determinations by the Office of the Data Protection Commissioner, most of, I think, save for those two, especially as at December 2024, all the rest were against private sector actors. So looking at the data, one of the questions that like you asked, why isn't the Data Commissioner taking action against private sector institutions? So one question that I usually ask myself is, for example, are Kenyans reporting violations by government institution, whether at the county level or at the national level, to the Office of the Data Protection Commissioner? And if they are reporting, perhaps maybe the data commissioner could break down and say, these are the number of complaints we've received relating to public sector handling of personal data. These ones are the ones we have made the determinations, we have dismissed X number, or we've decided to take action XYZ on the following. So I think that is data that is not in the public domain. And then, so what this means is that the public will always ask, why is it that you're finding private sector, you're not finding, no action is being taken against public sector? But one of the things that the Data Commissioner has done, especially recently, is to provide very clear guidelines on how public sector actors should handle personal data. And remember, yes, I have accepted when you look at the data, there has been no fines. Like, for example, you'll see fines, you'll see that we'll see compensation awarded against private sector actors, but the data doesn't show that there are complaints from does not show determinations against public sector. So I said, they have the Office of the Data Commissioner has now created, is now in the process of finalizing very clear guidelines on how public sector handles data. So what I will say is that perhaps maybe Kenyans should file as many complaints, legitimate complaints as possible against private sector actors, whether at the national level or the county level. And if the Data Commissioner has handled these complaints or has received these complaints, maybe it's to put data out there to tell us to what extent or what is the status of complaints that have been made against government.
And also, we've seen serious data breaches in Kenya. Recently, someone posted information of Kenyans from the information from eCitizen on Telegraph, and we've had such incidents before. The government has a lot of our information. Who bears the responsibility when such things happens? Who takes accountability?
So the Data Protection Act provides that the person who is accountable is the person who has this data in their custody. So the person who has effective control of our data. So, for example, if it is an institution, like I think you've mentioned, like eCitizen data, then the State Department handling that data that is hosted by eCitizen, or if it's KRA data hosted by Kenya Revenue Authority, it is the Kenya Revenue Authority that has the ultimate responsibility. If it is information relating to our passports, etc., it will be the Directorate of Immigration, etc. So it is that institution that has legal and effective control of our data that has responsibility. Then, of course, the Data Protection Act. So when you look at the Data Protection Act, it provides for reporting of data breaches. So one of the questions that perhaps needs to be in the public domain is how many of these breaches have been reported to the Office of the Data Protection Commissioner, and what action has been taken to ensure that Kenyans' data is protected? Because without this information, maybe the data commissioner maybe provide information. Have these breaches been reported? What action has been taken? Are there breaches that haven't been reported? And in the event that they haven't been reported to the office, also what action has been taken? Because the Data Protection Act mandates that where there is a breach of such magnitude, it ought to be reported to the Office of the Data Protection Commissioner.
And what is the pathway to reporting to the data commissioner? Is it capital intensive? Is it very difficult for Kenyans to how accessible is it?
Actually, if you wish to report or to make a complaint to the Office of the Data Protection Commissioner, report a breach, report that somebody is using your personal data for a commercial purpose without your consent. You go to www.odpc.go.ke. www.odpc.go.ke, and then there is a tab on complaints. And it's a very simple process, actually. You provide your name, your contact details, your identity details, and the nature of complaint. And once you make your complaint and it's received by the Office of the Data Protection Commissioner, they'll always acknowledge receipt, and they will tell you what action they will take. And the law provides that they must make a decision on your complaint within 90 days. And by and large, these decisions are usually made. So Kenyans shouldn't feel shy. You and I, we should not feel shy to report to the Office of the Data Protection Commissioner. So that is as per individual. Then organizations that have suffered a data breach could also report on the same portal, www.odpc.go.ke. There's a tab there that says report data breach. And then, of course, you give identity information and then report what is the nature of the data breach and what action has been taken, if any, related to that specific data breach.
Before we move on, there's something we Kenyans do that security guards in buildings expect. We share personal information, mostly names, IDs, phone numbers, and sometimes they can even keep your identification cards. I learned from you during our Twitter space with Mango Capital that there's actually a legal justification for that, and we should share that information. Could you explain that to us?
So around, maybe we can say around 10 years ago, when Kenya was experiencing a lot of terror attacks, a lot of tragedy relating to terrorism acts, the government then decided one of the laws that they came up with is called the Private Security Regulations Act. And this act, one of the things it provides for is that anybody entering a building or an installation or any location that has guards, etc., or has where we say management reserves right of entry, is that you and I are required, if asked, to provide proof of identity. So this identity could be our passport, could be our national ID, and that guard or that person manning the door or the gate or the entrance is empowered by the law to make a record of this is the person who entered here, this is their ID number, and they are allowed to retain your identity document until you exit. And the aim was to be able to identify who's getting into what building or location at what time. So yes, there's a law that provides for that. The question is usually, after these guards record our information on either a black book, mostly it's usually a huge black book where people can come and take photos and, just get that information. The question is, what protection do they provide for the data or the information they collect from us from those big black books as we get into our building?
Yeah, and are there measures put in place to ensure that that data being collected isn't misused?
the Data Protection Act and even the Private Security Regulations Act that allows them to collect our identity information also says that they're only supposed to use that information or that identification information only for the reason of confirming our identity, not for any other purpose.
But often some Kenyans provide false information. How can they verify that that information is indeed correct?
Yeah, now that's the challenge. Yes, sometimes if you give wrong information and they do not have the means to verify whether that information is correct, then there's really nothing. Then they have collected the faulty information.
But does it really keep us safe then?
Of course not. You see, all this action, the thing is that all this action by collecting this information, identifying ourselves, it's supposed essentially to be a security measure. But I'm sure you've seen in certain you go to certain buildings or a mall, and even the guard, they don't even frisk you. They just tell you, they just let you pass through without doing due diligence. So yes, it's also, I think over the years, it's a very broken system. Unless, of course, you're getting into a security installation. For example, of course, if you're getting maybe into parliament, into state house, into certain government ministries or departments, there might be more scrutiny on your identity. Or if you're going to an embassy, but otherwise, in the entire year you're coming to my estate or to my building, no, I don't think they have any way to verify whether the information you're providing is. So they do it mechanically. Now it becomes just a tick box, something just to check a box.
That's unfortunate, huh?
Yeah.
So we've established that the state can surveil for purposes of national security to keep us safe, and that's granted. But at the same time, there's growing concern among Kenyans that we might be drifting towards a surveillance state that's enabled by having access to our data through tech, the tech we use daily. And we've seen telecommunication companies allegedly being accused of enabling abduction, censorship, and targeting of activists, especially since 2024-2025 protests. And we've had talks of media laws by our lawmakers. Could you help us understand the safeguards in place that can guard us against this drift?
Okay, let's start. The government, even in the constitution, national security organs are empowered to carry out investigations, to carry out surveillance. So even when you look at the police laws regulating the police, the National Intelligence Service, either military intelligence or all these DCI, they are allowed by law to collect data, to collect information, to carry out surveillance, but for a valid reason. And the law provides that, for example, whether it's DCI or NIS, and they want, for example, to track your phone, to track my phone, they require a court order. They require an order from the court saying that Officer X, who is of a certain rank, is allowed to carry out communication surveillance against this individual for X number of period for investigation of this or that crime. But there's what is stated in the law and what happens practically, because one of the challenges that we've had, for example, if you look at the case of Albert Ojwang, the question was there a warrant? Was there a warrant that had been signed or allowed by a court of law to allow for the DCI to go up to Homa Bay, track Ojwang up to Homa Bay, abduct him, and bring him all the way to Nairobi? So there are these set out legal procedure where the court order, the warrant has to be there. But of course, there are many instances where you find that the surveillance carried out by these security officers without following these legal procedures. For many years, there's been talk about a software called Pegasus, which is a spyware by NSO group that somebody can remotely upload it on your phone or on your device, and they're able to read, to get access to your social media accounts, your text, your camera, your microphone, etc., etc. Of course, the Kenyan government has never confirmed whether or not they are using this kind of spywares, and there are many other spywares that can be used. So Also, when somebody is arrested and the police get hold of your mobile device or your phone, they also have technology that if you don't provide to them your passcode etc, they can actually they can actually get into your phone, and even where you had deleted data, they can extract it, and get to know who have you been communicating with, what kind of websites or social media information do you access etc. But also remember, there's a lot of information publicly about us. So you and I, for example, Sumaya, if I was to search you perhaps on LinkedIn, you are on LinkedIn, perhaps you said you went to this university, you work here, etc. So somebody is able to, even if it's not updated information, somebody is able to know, okay, Sumaya works in this location, she went to university here, she's taking a certificate or a diploma course here, she's doing her postgraduate here. So somebody is also able to track you. Then, for example, if you post information, let's say on Instagram or on Twitter, if you post information about where you live, for example, who your siblings are, who your parents are, who your relatives are. Somebody is able to tell where your ushago is, where your children go to school, where your nieces and nephews go to school, where you go to worship, the restaurants you like. So with this information, using open source intelligence tools, open source intelligence tools, this may be used to get you information that is publicly available from website, from social media pages, and from leaked databases. So you see, when you talk about these data breaches, when there's a data breach, the information that is stolen from these databases is usually collected and sold in the dark web. So there are people who usually go and purchase or access that database and try to create a profile about certain individuals of interest. Then, of course, also telecommunication companies also have our critical data, especially what we call data records. And ideally, in an ideal situation, is that before these security agents, these police officers, DCI, etc., can access those call data records that are housed by telecommunication companies, they need a warrant, they need a valid court order to take it to the telco and say, hey, we are investigating so and so, here's the court order, we need you to provide us the following information for the following purpose. But remember, the police can also get they can also get information from available on social media, or they may have surveillance spyware like Pegasus. Then, as I said, all of us, we post things on social media, so it is easy to somebody to track us down. Then remember, government can also ask these social media platforms for information. So either through a court order or a request, the government can request, let's say, Facebook, TikTok, X, WhatsApp, that we want information about person X. We want to know who they communicate with, or especially if somebody posts anonymously, they're able to track what email address did they use to register, what phone number did they use to register, what is their location, etc. And with that, then they're able to track individuals. Then when you look around the city, I mean, there are cities with cameras. So there's a lot of surveillance cameras all over the city, especially Nairobi and Mombasa. So people, I mean, if I don't know, but perhaps if they have facial recognition and AI powered, then they're able to know if I'm in Mombasa and they can tell, this person has been in Mombasa, this person went towards Naivasha Road or that road or Kiambu Road, etc. So as you see, there are a lot of sources where data can be sourced from, legally and illegally, procedurally and unprocedurally. So security officers can use a combination of all these data sources to track us, to know our location, to know who we communicate with, to know where we live, etc., etc. All right. Then our phone, remember, if they get the call data record from a telco, they're able to also get our mobile phone money. If you pay utilities, they're able to see where, if you pay, for example, for electricity, for water, or any other utility, they're able to track to know this person lives around this area. So at the end of the day, when you look at all these surveillance methods or tools or methodologies, the answer is that you and I, we can't evade all of them. So it's nearly impossible for us to evade all these tools that can be used by government to track us. But what is important is that if, for example, you've been subject to investigation, you've been charged in court for whatever reason, and there's evidence that is provided by the investigators or by the prosecutors relating to information from your mobile phone or your device, then you're able to challenge and ask the question whether that information was obtained procedurally with a court order or with a valid warrant.
Have you seen an instance where that happened?
Yes, actually. Recently, I think this year, the planners or the facilitators of the DUCIT terror attack, they challenged phone data that had been submitted to court by the investigators. So when they challenged it, of course, the court identified that that data had not been procedurally obtained. But the High Court said that this was a special case because this was a terror attack, and then that the public interest of having that information outweighed the privacy of the individuals, because it stated that that data showed who they were communicating with, the payments that were done to facilitate the terror attack.
That's interesting that I think a terrorist will know more about what to do than the young activists we see being abducted daily.
You see, you can't run away from these technologies. I think I've explained that there are different sources that your information can be sourced from. So it's nearly impossible, maybe 0.001% from you to hide forever from these surveillance tools.
Yeah. The way you've laid out all these things, it seems like we're living in scary times. Like, tech is amazing, but when someone lays it out the way you've laid it out, you just start to get worried.
Yeah, and remember what I've just mentioned is just by the government. Remember also private sector actors like these platforms that I mentioned that. So let's say, for example, government makes a request to X, Instagram, Facebook, etc. about our data. Remember how much data does these platforms have they been collecting from us for all those years we have been subscribed to those platforms. And you can imagine now if they are able to give that data, if they are legally able to give, illegally or illegally able to give that data to the government, then it's very easy to track you and I. So essentially, it's just to say that, yes, surveillance is there. We can hardly hide from this surveillance. But what is important is to know how to react and perhaps make it difficult to have, though in this day and age it's not easy, to make it difficult for people to easily track us down.
Yeah, and you've mentioned these big foreign tech companies like Meta and Twitter. Globally, these giants are facing increasing pressure from governments to comply with state demands, like you've mentioned,
Yes.
whether it's on censorship, shutting down protests like we saw in Turkey with Twitter, and even demands for data on users by the state, like you've mentioned. And recently in Kenya, we've seen increased intimidation linked to online speech that has heightened public anxiety over the state's response to dissent on social media platforms. How do you understand the relationship between these big tech companies and their collaboration with governments, and what this means for free expression in this private town square, and our civic space and accountability? Because Twitter can easily say that they're a private entity and they have the right to determine who they want to serve. So where does that leave us when it comes to free expression and democratic discourse?
You see, this public square that we mentioned, that is X, or that is Facebook, or that is Instagram or TikTok. Yes, ideally, as you say, these are private enterprises. And these enterprises have terms and conditions, have community guidelines on what kind of expression that we put out there. And with these terms and conditions, then they're able to carry out they actually carry out censorship, especially if you discuss topics that for some reason they don't like. I think you saw this during the COVID time. Individuals who are against, for example, the COVID vaccine, or taken off the platforms, in the current conflict, the genocide that is that is being orchestrated by Israel, for example, if you support the rights of Palestinians not to be subject to genocide, you're kicked off some of those platforms. So it's a public square that has rules that are detrimental to the right of free speech. You also find that, for example, during the presidential elections, especially when you look at the U.S., is that there are people who are supporting President Donald Trump. They were kicked out of some of these platforms. Donald Trump was also kicked out. But of course, there can be argument that they were saying things that were ridiculous. For myself, I also feel that some things they were saying were out of line. But you see, we are either pro-speech or we are not pro-speech. Because if we start limiting speech on these platforms, depending on our sentiments or the feelings, then you sort of break up that public square concept. And the fact that governments these days, they say that they tell these social media platforms is that you either provide us this information or we don't allow you to operate within our borders. So what do these platforms easily do? They easily give access to this government of any data or information that they so wish. And there's basically nothing we can do about it. Meta has been challenged in the Kenyan court. I think it was in 2023 that matter was filed. And one of the arguments by Meta was that they were not subject to Kenyan law. But the High Court said, no, because Meta is operating in Kenya, then they are also subject to Kenyan law. Meta appealed to the High Court and to the Court of Appeal, and the Court of Appeal also said, no, you are subject to Kenya's constitution. So you must comply with Kenya's constitutional principles.
What exactly was Meta arguing against?
They were saying that because they are not registered in Kenya, they don't have an office in Kenya, then they should not be made to be subject to Kenyan law.
Oh, that's bizarre.
That was the argument.
I think one of the things you mentioned is we need to be pro-free speech. I remember, like you mentioned, during certain times, and we've seen this maybe in other parts of the world, but we also saw this in Kenya, where there was a lot of talk about disinformation, misinformation, false information. And one wonders, or rather, I used to ask, what is the line between what misinformation is and free expression, because it can easily be used by the state to shut down speech. I don't know what your views are on that.
Yeah. In the same view, and who determines what is misinformation and what is disinformation? Because we could be seeing something from different angles. Yeah? You see, for example, myself, I put on spectacles. I think you also put on spectacles.
Yes.
If you remove this spectacle, our view, especially of colors, depth, distance, etc., is a bit skewed. It's just because of the challenges we have with our eyesight. So people see things of different perspective. And the public square, when you talk about the public square phenomena, is that you allow all different kinds of speeches, so long as they are not harmful, because of course there's harmful speech. If it's speech, for example, incitement to violence, incitement to genocide, if you're defaming someone, that of course is harmful speech. But where it's speech that is not harmful, then it should be allowed in the public square. Because there's a book I read that one of the things that you need to do when you leave facts and the truth to walk freely, you will never need to defend them, because the light will always shine upon the facts and the truth, whether we like it or not. In as much as you try to suppress it, it will always come out open. And this is the thing that we always should also allow speech that we do not agree with, speech that makes us angry, that makes us upset, because it is with that then we are able to, the truth is able to sift itself to the top. The facts are able to be sifted and to be analyzed and to be challenged. But if we automatically say we don't like people who are criticizing the government and we shut them down completely, that is dangerous, because one of the core components of a democracy is political speech. The fact that I'm able to either praise or criticize my elected or appointed public officials.
On the same breath, last year during the 2024 finance bill protest, young Kenyans were sharing phone numbers of politicians, the whole Msalimia campaign. There are those who claim that what they were doing was illegal because they were doxing these politicians. But there are also, some of them will extend it to the relatives of the political class. Is it illegal to share the phone number of a politician and their relatives?
For a politician, no, because of course, when you look at the constitution, there's a provision on accountability and transparency for these politicians. But for their relatives, there can be an argument that says these are not public officials, so doxing them will be violating their right to privacy.
And we also saw some politicians suing Kenyan activists for defamation during these periods. And at times it feels like they try silencing people, their critics, rather, using defamation laws.
I think it's a good thing. It's a good thing. At least they go for defamation instead of abducting and killing.
Yes.
And instead of joining. And it also remember that they also have a right to quote unquote a good name or not to be defamed. So it's basically simply, if they feel that they have been defamed by whatever someone is saying, let them have their day in court, let them explain, because some of them, they usually say they have good character or moral standing, and it's easy to prove that they have no character of moral standing to protect. So some of those cases really, if defended well, will not go far. So I think it's a good thing that they are going to civil courts to challenge information said about them or speech against them.
Yeah.
What will amount to a chilling effect will be where now they are using the police, people are being arrested, people are being abducted, people are being disappeared for whatever they are saying. But if it is through a civil process, I fully support. Let them now justify that they are of good character and moral standing, or they have any character to protect.
On June this year, during the protest anniversary demonstrations, the Communications Authority issued a directive ordering all television and radio stations to stop live coverage of the protest. And the authorities claimed that this was according to the Constitution. I remember you stated on social media that this directive was unconstitutional. Can you walk us through your legal analysis of what happened here and how, and yeah.
You see, the stop of the live proceedings was to stop announcing or having live coverage of Kenyans exercising their rights to picket, their right to demonstrate peacefully. If you note that actually the people who are demonstrating generally were demonstrating peacefully. And I think the government did not want people to see that actually there's peaceful demonstrations that are ongoing.
Yes.
Secondly, this was a violation of the right to freedom of the media. Remember, that notice given by Communication Authority did not provide a justification for the halting of live proceedings. Ideally, there should be a notice that's saying, hey, according to this provision of the law, we want you to hold proceedings, and the reasons are the following. This one had no reasons at all. And even before, many months ago, the High Court had indicated that it is not within the mandate of the Communication Authority to regulate the broadcasting code. The court said that should be the role of the Media Council of Kenya. So essentially, the Communication Authority, by issuing that notice, was actually going against a court order that had been set out about who is to regulate the content within the broadcast media. And of course, I think there are two cases that were filed, two petitions were filed by Katiba Institute and another one by the Law Society. And of course, the court issued an injunction, a temporary order stating, no, these live proceedings should continue. And then remember, the Communication Authority Director at some point now came out, I think it was 1 or 2 days later, came out and said, no, I did not mean stop the live. I meant, so he was trying to sidestep the directive that he had provided because of the hit that he was getting, that ideally that was not within the Communication Authority's mandate.
And those who like to, I remember we had this discussion with you about people who like to blow the whistle by when exposing abuse or wrongdoing, especially by the state or even the private sector, but mostly by the state. Do they have an avenue to speak out safely without harm being imposed on them? Like, are there protections that exist for these people who want to speak out about an abuse or corruption? And have we had such cases in the past? And were they as per the law required?
Essentially, we don't have. I think that there have been drafted whistleblower protection bills in Kenya, but they have not really been there. What the law that we have that perhaps will protect a whistleblower is the Witness Protection Act. So essentially, if you're a witness in a case and you're a whistleblower, you can go under witness protection, your identity, your location protected, etc., etc. But then there's also protection. Okay, ideally there ought to be protection. For example, if a whistleblower reports a violation provide information to the Auditor General, to the Kenya National Human Rights Commission, to the Gender Commission, that of course their identity and the source of the information ought to be protected. And I think it's for this reason that you find that individuals who give journalists information, then journalists have a statutory right to protect their sources. So there are avenues that can be used to protect a whistleblower. But where the whistleblower themselves decide to go public without following these avenues, then it becomes a bit tricky, because you've seen whistleblowers who have sort of sought asylum outside Kenya because of the kind of information that they have leaked. So yes, there are avenues that could be used. We don't have strong laws that are very clear on whistleblowing, but there are laws that we can leverage on to protect whistleblowers.
And are there notable events in this country where someone blew the whistle and we saw the aftermath of what happened?
Long ago, there was a Golden Bag scandal, which related to central bank issuing compensation for gold exports that were never there. And there was this gentleman, he was called Munyakei, who used to work at the central bank. I think he was a clerk or something at the central bank. But I think he was mid-level or below mid-level within central bank. And after his whistleblowing, his life turned upside down. And he passed on a really sad person, because he really did not get the protections that he really wanted.
What happened to him? Like after he blew the whistle, what?
I think he couldn't get work anymore, because you see, also people don't want to hire people who, if they know Sumaya blows whistles, they'll say if you apply for a job, they'll be like, hey, no, be careful of this one. They might expose us. So unfortunately, so his sources of income really dwindled, and even when he had serious health problems during his end of life period, he didn't have much resources to take care of himself.
That's rather sad, huh?
Yeah.
And
Very
I
sad.
wanted to ask you this question. You know, as someone who works in tech, at times people feel like they feel constrained by some of the data protection laws. And I think guys who work in fintech, they were making the argument about WorldCoin that was taking the iris of people, especially, and that the motive was to drive financial inclusion for various financial services. And the lack of unique identifications in some communities acts as a constraint in serving those communities. Do you think that WorldCoin should have been allowed to operate, and we should have found ways of ensuring that they were acting within the law? And this also, now think of it as within other areas in the tech space, whether it is the health tech, where a lot of people feel, especially in health tech, they feel highly constrained by the data protection laws.
You see, it's simple. If you're in health tech, why is it you want somebody's data without having to inform them? Why do you want to go to a hospital, get her data about Laibuta's health data? You don't want to tell Laibuta that you've accessed his health data, but you want to use that health data in whatever way you so wish. Really, we can't allow that. At the very least, just tell Laibuta, yes, we are developing this technology, and as you come to this hospital, we wish to request your data about XYZ. And over the years, I mean, especially health data, there are very clear guidelines on protocols on how to access health data for research purposes. So what some people want to do is to access people's data and information that is very private and very sensitive without requesting them. Like, for example, Sumeya, let me give you an example. Look at the last, I'm not saying you disclose, look at the last time you went for medical care or the weather checkup, etc. Will you be comfortable if I went to that hospital and say, I said, give me Sumeya's file, I want to use Sumeya's data to create an app? Will you be comfortable?
No, but Kenyans give up.
No, simple.
No, I will not be comfortable.
Yes. So it is the same. And see, Sumeya is a well-informed and enlightened Kenyan. Now look at those Kenyans who are not as enlightened that they are due, because one of the things about WorldCoin, which also the court stated and Parliament stated on it, that we are not saying WorldCoin should not operate. We are saying, please, WorldCoin, as you are doing this, you need to inform people fully what you're going to use their data for. You need to be open. You need to be transparent. We are not saying we don't need unique identifiers. No. We are just saying, as you craft your tech, as you are doing your technology, whether it's assessment or trials, etc., please ensure that you follow certain protocols. Don't assume that people's information is up there for grabs, because this tech is just the same thing I've asked you. Usually ask this tech is, will you be comfortable, for example, Sumaya, if I told you, give me your phone, I go through your Instagram messages, or I go through your WhatsApp messages, or I go through your bank statement? And the answer will be no. Why? Because this is private information. But if somebody requested this information and those are very clear guidelines on how they access this information, they give you the reason, and you're comfortable with them getting that information, then you'll say, fair enough, you can have the information within the certain conditions that we've set out.
But that's how people give away information on tech platforms easily. Because even with health tech startups, when you look at how a lot of the platforms are set up for the HMISs, it's just most guys don't even read, even the clinics themselves. Because I worked in health tech and I remember they never even used to read the contracts until an issue came up. And the patients will just click on the I consent button.
Yeah, and it's because you see, you and I know it's a privacy violation when you access people's health data and you're not a medical professional. But we want to do it because we are saying we are innovating. How sure are you that you are innovating for the right purpose? How sure are we that you're going to use that data for the correct purpose? So what is being said is that innovation can occur by also protecting, I think when we started here, we're talking about the dignity and the privacy of the individual, by protecting people's dignity, privacy. But of course, where even the Data Protection Act identifies that there's information that people put out there publicly. You and I post on Instagram, X, TikTok, LinkedIn, etc. Then which means that information is available to anybody who is in a position to extract it. But you see, that is different from where you go to an installation like a school, like a hospital, and ask for the patient register or patient records, or ask for the student's register or student's records. So if it is out there and it's public information, sort of the Data Protection Act identify where the data subject, the individuals have consciously put that information out there.
Do you think a lot of people understand what exactly they're consenting to on those platforms?
Of course not, because the person who is seeking that consent is never wants to be transparent enough. You don't want to explain to this person in very clear language what is it you're going to use their data for. Like you see, with the WorldCoin situation, the issue of transparency, the issue of being very clear about what this data is going to be used. So what is the purpose? What is the benefits, etc. People felt that that was too much information, that you give us your data and shut up.
Fair enough. But don't you think that so let's say, for example, in healthcare, one of the things we used to notice was it was really hard for us to determine like what how to assess risk, especially in insurance, if you don't have access to that data, and in building micro insurance products, which would be more expensive than your regular insurance product.
And see, insurance is that's why you give when you are seeking when somebody is applying for an insurance product, then you tell them to assess risk. You tell them, do you consent to us getting data, getting information about you, so that we can assess the risk of this insurance? And a lot of insurance do it these days. So
Yeah.
I think it's people feel that. That's why I go ask these techies, will they feel okay if we went to hospitals and extracted their data? If we went to the bank and got Sumaya's bank statements, then we go and get the Sumaya's health data. Then we go to the university you went to, we get your academic record, and you say, no, we are doing this for public good. Sumaya shouldn't complain, because why should you complain? And we are doing this for your benefit.
Fair point. And then the other thing I've just remembered was, like, it seems like every now and then the state is trying to access our financial data and in real time. And this is mostly in regard to M-Pesa, and has raised the question about the thin line between tax enforcement and invasive surveillance. Do you worry that we could get to a point where dissenters will ever be denied access to financial services at the behest of the state? And why is it that they're always pushing for access to access our financial data, especially M-Pesa?
Remember, the Constitution provides that every Kenyan should pay tax, that no Kenyan should be tax exempt. So let's start from that point. Then, because of that, Parliament enacted what we call Tax Procedures Act, which has been in place for a very long time, which says that KRA has the powers to come to your business and say, hey, we've realized that you've not been paying tax, or we think you are underpaying tax, and we want to carry out an analysis, so we need records and information from you. So they do this formally. And then you can go to the Tax Appeals Tribunal. If you're not satisfied by this, then you can also go and appeal to the High Court, etc., etc. So it's a procedure, because, as I say, the government provides that all of us must pay tax. So in the event that the tax man realizes that maybe person X is not paying taxes, then they use the Tax Procedures Act to get information about you and to audit you and to say, hey, this is the X amount of tax that you need to pay. But also remember, the Data Protection Act itself says that one of the legal ways to handle data is if it's in compliance with a legal obligation or a legal requirement. And taxation is a legal obligation, it's a legal requirement. What we are against, or a lot of Kenyans have been against, is to have blanket access by the taxman of our data. What you're saying is that let the taxman follow the Tax Procedure Act and come and tell me what data do they require from me. But when we say that they should 24/7, 365, they should have access to any and all data at all times, then that, of course, becomes problematic, because the question now becomes, if they have unfettered access to, for example, my M-Pesa, my social media, my bank accounts, then is it solely for taxation purposes, or could it be used for other purposes? So let them first inform me they want X data. Then I tell them, yes, I agree. I'll give you X data or X documentation. Then if in the event that any of us is aggrieved or we don't comply, then we have the tax appeals tribunal and we have the courts to deal with the issue.
Awesome. Doctor, you studied data protection globally. When you look at how other countries handle their issues compared to Kenya, where do you think like our strengths lie and where do we fall short? And what do you think what are the necessary steps we need to take to strengthen our data protection laws?
I think, like you mentioned earlier, the question you asked about action being taken against the public bodies, I think that's an area of really improvement. Something else that I think you've mentioned is, are people well informed about their rights? And the answer is no. But of course, when you look at, for example, the data commissioner has been engaging in a lot of public education campaigns. They are quite resource intensive. So they may not have reached everyone within the republic, but for example, the Office of the Data Protection Commissioner has established regional offices, I think in Kisumu, Nakuru, Eldoret, Nyeri, Mombasa, Nairobi. Can't remember the other. Anyway, but at least there are 5 or 6 regional offices where Kenyans in those regions are able to access the Office of the Data Protection Commissioner. But definitely the issue of public education to understand, for example, because of the WorldCoin scenario, people are just being told that come and scan your iris and we'll give you some bitcoins later. And they had no idea what this meant. People just it's on the promise of some money, which they didn't know it's not, you're not being given the cash there and then. So that the issue of public education is quite a challenge, which means that perhaps we require more resources to the Office of the Data Commissioner to be able to carry out this public education, to also carry out audits and inspections of especially public entities, and maybe the fines. When you look at the fines against people who mishandle our data, perhaps they are not punitive enough. Maybe that's something perhaps to look at and inquire about. But when you look at the determination by the data commissioner, they indicate that yes, action is being taken against violators of data protection laws and the right to privacy, especially where it's reported. Where you report and you follow up with the commissioner, then action is taken. Then we have the Kenyan courts that have consistently protected Kenyans' rights to freedom of expression. So even if you're not happy with what the data commissioner said, you can go to the High Court. So there are all these avenues that are available for us, but also what I've mentioned, what is falling short. Then also the fact that, and like you mentioned, techies are complaining, and I agree, I have to accept that it makes it a bit more expensive, not even a bit, it makes it more expensive to innovate, where you have these regulations to comply with. So, and in the current economic climate, you find that a lot of data handlers find it a bit expensive to comply with these regulations.
Amazing. And the other thing is, as Kenyan citizens, what can we do to protect ourselves? And yeah, what can we do as Kenyan citizens to protect ourselves? Because there's something you said in another podcast. How you protect your information determines the kind of surveillance being carried out.
Yeah. So there are many things, of course, to secure our device. I mean, to make it harder for somebody if they got our device to get into it. So if you have a mobile phone, for example, I mean, having a code, a password, being able to trace it. What can I say? If you're using an iPhone, or you're using an Android device, having a method in which you can trace if it got lost, to wipe it clean. Using measures like two-factor authentication on your online platforms, whether it's your email, your bank account access, seeing your social media access, etc. So it's having very complicated passwords that are not easy to crack, so that it's not Sumaya at 123, for example. Then also to be careful what kind of data, what kind of information we post out there, because on social media you find that we make it very easy for someone to profile us. That people from just simply from social media, somebody is able to know who my relatives are, where I live, the work that I do, how I move from one place to another, whether it's using public transport, whether it's having private means. If I have a vehicle, people know its plate numbers. They know my house number. So there are simple bits of information that we can essentially keep private to ourselves to make it harder for someone to track us.
I think one of the most interesting things I heard you say is you have a friend who uses Luya vegetable words as passwords, and he's like, it would be quite difficult for people to guess those passwords.
Yeah, you see, like, if it is Obusuman Lisebebe at 1997, how do how do you crack that?
Yeah, true. Um,
Yeah, so
Actually,
just think about your mother tongue, and think of those complicated terms. Then you add a space, you add a character, you add the capital, small letters. It makes it a bit harder for someone to track you. It doesn't mean that it will eliminate the possibility of you being profiled or tracked, but it just makes it a bit harder.
yeah. Let's say
Yeah. Then
yeah.
yeah. Then also to regularly change. I mean, just like our banks usually do, they tell you that after every X period of time, you need to change your password, your access. We can also have the same kind of habit.
Yeah. Doctor, you have rather an impressive academic background and you've been at the forefront of legal protection in Kenya. How did you get into this space and how have you seen it evolve over time?
I got in by accident. So I think you remember. So when Twitter, when it was before it became X, so like 12, 13 years ago, or even more, on Twitter, it was a very small community. And even before that small community, what was most common was blogging. A lot of people will have blogs where you will subscribe. So we will get these blogs via email, for example. Then X and Facebook came, and there was sort of a common platform, easily accessible platforms where people could engage in a digital public square. Then during that time, I mean, as things progressed, then we'll find that people who had said some things, especially that was critical of the state or critical of certain politicians, were getting arrested. Mostly arrested. Mostly they were not charged. They were getting arrested and harassed for things that they posted on X or Facebook, etc. So because of that, we felt, no, we need really to protect this space. So during that time also, the Bloggers Association of Kenya had also been established, and one of its mandate was to create a safe space and to protect the welfare and interests of bloggers in Kenya. And at that time, bloggers was a word that was taken loosely. Anybody on social media was taken as a blogger, and I think that's why that name has stuck. And so with this, we were able to represent these people who are being harassed by the state, by state actors, security agents. And because of that, I realized that this was big because now it started becoming too much. And because of that, with the Bloggers Association of Kenya, we created a training program for bloggers about their digital rights, their right to freedom of expression, right to access information, intellectual property rights, their rights as an arrested person, because a lot of them were being arrested, their rights to a fair trial. So we took a lot of bloggers through this, and there's also a lot of information being posted on Twitter about how to react when one is arrested, if action is taken against them. Then there are also quite a number of cases that were there that participated as a researcher, especially challenging old colonial laws that were stifling the right to freedom of expression and digital rights. So after training the bloggers, we also created a program to train lawyers who will be able to protect the interests of these bloggers in the event that they got into conflict with the law or individuals. And so carrying out a lot of research, carrying out this training, then I got interested in doing more research and more work in this space, but I focused on privacy and data protection because also that period between 2016 and 2018 is when the European Union were going very public about them changing their data protection laws. So I felt that, yeah, maybe this is an issue that I should branch to. But also I've written a lot and trained a lot on the right to freedom of expression in Kenya, around Africa. I've written on internet shutdowns, and of course I've written a lot on data protection and privacy in Kenya. So that's how my interest, and as a lot of people also got interested in this space. Then, of course, when the Data Protection Act was enacted in 2019, there were more people interested in the opportunities around the Data Protection Act. And the professionals have grown. For example, I'm the chairperson of the Data Privacy and Governance Society of Kenya, where we have around 750 signed up members who act as data protection officers in public sector, private sector, academia, not-for-profit sector. We also have university students that we mentor. So the space has also become a source of income, a source of employment for quite a number of Kenyans.
Lastly, how can young Kenyan activists who go out there to protest protect themselves?
I think so. Kenyans to protect themselves. So there are several things that you'll find that, for example, the Law Society. So if you go the Law Society of Kenya, every time that there's a protest, usually sends out a list of what do you need to do. One of it, of course, is to ensure that that you engage in peaceful demonstrations at a very bare minimum. Ensure that it's peaceful demonstration. Avoid any destruction of property. Inform, if you're going to demonstrate, inform someone your location. Avoid being in a situation where your phone is without battery 100% during the demonstrations. Then if you're arrested, please let people know if you're able to do so. Call someone or inform someone you are picketing with, you're demonstrating with, that you're actually being arrested. Then something else, of course, is the fact that take as many photos, as many videos as possible. To ensure that it is documented. Whatever you are doing is actually documented, because as you've noticed, a lot of Kenyans have been kept safe by purely documenting what is happening around them. But what is most important, demonstrate peacefully. Of course, the police, even if you demonstrate peacefully, the police come and the police become the violent actors.
That's true. I think we'll end it at that. Thank you so much, Dr. for your time and for the insights that you shared with us. I will share Dr. website for those interested to explore some of his contributions to data privacy and privacy, data protection, and constitutional rights. And you can go and visit his site to see some of the contributions he has made. Thank you, Dr.
Most welcome, Sumaya. Thank you for the invite and thank you for the conversation.